Good afternoon. Thank you for joining us today. I'm Teresa Phillips at Boughman. I'm so happy to announce that Eric Bowman's here with me. He's my colleague and partner. Unlike me, Eric doesn't primarily practice in the areas of probate, guardianship, and fiduciary matters and litigation. He's more on the business side of things, but he actually has had some real life experience in his practice with guardianships in particular. And he's going to bring, I think, what's a pretty interesting and unique perspective to our review today. Thank you for being here, Eric.
Absolutely happy to be here, and thanks for the opportunity for everybody to participate.
Thank you. So today is Florida Guardianship Law, protecting the elderly and preventing abuse. Just to go briefly, let's start with our agenda so you can see what the areas are that we're going to try to dive into in the next hour. After our introduction here, we're going to look at some aspects of Florida guardianship law, an overview of how it works as it relates to the elderly. And then we're going to look at some proposed changes that are on the horizon and see how those might change things up and bring everybody up to date on the status of the law in general. But we want to really focus today on how elderly folks are sometimes affected by the guardianship law, and kind of look at this in ways that maybe that sometimes the guardianship law fails them and doesn't quite live up to what we hope it does, and really get into some of those kind of issues that might help practitioners that might be listening today, or people who may be going through guardianship matters. And that brings us to the fourth part of the agenda, where I'm looking forward to Eric really giving us some litigation perspective on that. The weaponization of guardianship. That's a coin that I think our firm has come up with, and what we use to explain when the guardianship rules and statutes are used to against people, not for their actual purpose, but against people to gain leverage on folks and gain some kind of usually financial benefit. And unfortunately, there are ways where unscrupulous people can do that. And we're going to talk about that. And Eric's going to have some advice on possible ways to try to keep that from happening, trying to do some pre-planning. And then, as always, we'll have our conclusion and an opportunity for questions. So why is this topic something I'm always bringing up, the elderly and guardianship law? Well, Florida is a elder rich nation, or an elder rich state. Just look at some of the statistics here. They lead the U.S. in the concentration of older adults. More than 18% of our total population is comprised of residents 65 and older. In 2025, it's estimated that roughly 940,000 residents in the 65 and over bracket, including 130,000 of those who will be 85 or older, will call Florida home. So that's a significant elderly population, and therefore it's a significant issue for us to address. But look at the future. By 2034, people in the 65 and older group will outnumber those in the 18 and older group for the first time. So while we're looking at these issues, just think about that. It's only going to become more and more relevant as that population grows. Here are the dynamics that we're looking at what's, if you look at the elderly family dynamic in 2025. There's a term now called elder orphan, which describes any person who is aging alone with no family support. And I can say from my own experience, my own observations, I've seen more and more of this. I would say 20, 30 years ago, that was a rare creature to find an elderly person that had no family support surrounding them, but it's becoming more and more common. And I think as we discussed how guardianship laws act and how incapacity can come into play, you'll see why when someone's an elder orphan, they're more susceptible to being a victim of maybe some unscrupulous activity. 2016 study estimated that 22% of people aged 65 and older in the US are at risk of becoming elder orphans. That's staggering to me. AARP says that 1 in 5 Americans over 65 are either already elder orphans or at risk of becoming so. According to the 2023 current population survey, about 28% of people aged 65 and older in the US live alone. This accounts for nearly 16 million older adults, with about 10 million being women and 6 million being men. In Florida, family members are the most common perpetrators of elder abuse, including financial abuse, emotional abuse, neglect, and physical abuse. And as Eric and I will discuss as this goes on, I think sometimes guardianships can be used as part of that financial abuse aspect. So let's look at the law. We obviously in 1 hour, we're not going to be able to go over the comprehensive outline of the Florida Chapter 744, which is our guardianship law. But I want to focus on that's most likely to affect elders, and that's the incapacity. One of the ways you can start a guardianship proceeding is to start an incapacity proceeding. With incapacity, meaning that someone doesn't have the legal capacity to make certain decisions in their life about their financial and physical well-being. So if you wanted to start something to bring the elder person into the guardianship realm, you would start with an incapacity petition alleging that this person is incapacitated and state certain facts. I'm going to cite throughout today to the Cook Court, and I have a citation for you for those who would like to read it themselves. It's a 2018 decision, appellate Florida decision, came out of the 4th District. It's Cook v. Cook, and I'll get you the more detailed citation at the end, and I think it's also in the materials. But when I'm talking about the Cook Court case throughout this, it's one of the few detailed cases we have in Florida where the judge really examined whether the procedure was being used against Mr. Cook, who had been alleged to be incapacitated by his 2 brothers. But the Cook's court stated in there, being declared incapacitated will deprive an individual of more freedoms and liberties than those suffered by convicted criminals. And really, I think that shows the gravity of what we're dealing with here. And I've seen guardianships. If you're in a plenary guardianship, you don't have the right to even visit with people without your guardian's permission. They can isolate you. They can keep you from making calls. A lot less liberties than what you may have, what most people would experience through the judicial criminal system. Now, sometimes that's for people's protection, but you could probably see that it would be remiss of us not to accept. That's a pretty grave situation to have to declare someone in a state to declare someone in, and it should be done only in the circumstances where it's necessary. And I think as we go through this, the statutes, the legislative intent, the case law emphasizes that this needs to be treated with seriousness and only used when absolutely necessary. Number 2 here, pursuant to Florida Statute 744.331, subsection 6, an order determining incapacity must be based upon clear and convincing evidence, not just more likely than not, but clear and convincing evidence. And with respect to the exercise of particular right or all rights, I think this is the legislature indicating they frown upon just blanket incapacity determinations and really wants the courts to look at particular rights and leave rights intact that may be left and keep the ward safe. Number 3, the court is required to determine the person's unique needs and abilities and may only remove those rights that the court finds the person does not have the capacity to exercise. Again, this is more statutory legislation, and it means nobody should just be treated as you have one kind of condition, and let's just presume that you should have all your rights removed. Look at what this individual has. What's unique about them? What do they actually need, and what maybe do they have abilities to do? And I would argue that those abilities, that would include the resources they have around them or resources they have put in place before their incapacity. Number 4, the requirement of clear and convincing evidence. That we're going to quote from a court that dates back to 1939, the Florida Supreme Court there. This court must closely scrutinize the petition to ensure that there were sufficient ultimate facts that would necessitate court intervention such that a plenary guardian would be appointed over Mrs. Smith, who was the ward in that case. Petitions for incapacity should always be closely scrutinized to see that the sufficient ultimate facts appear, and courts should be meticulous in requiring sufficient evidence to be addressed or to be adduced to show the existence of facts which create the necessity for the intervention of the courts. Now, these are just some legal citations from the Cook case and statute that just goes, I think it gets overlooked sometimes, that the courts are charged with looking at these petitions, looking at with individual needs, and not giving blanket incapacity orders. And I think this is going to come to play in our discussion as we go on. That is the procedure that we actually use, and we go through with incapacity petitions under the guardianship law. Is it really serving this purpose to the best of its ability? We'll talk about that and see if what everyone thinks at the conclusion of this. More of the purpose. The very purpose for such a high degree of scrutiny is to ensure that these proceedings are not being perverted so as to deprive persons of the very rights guaranteed to them by law. It's ironic that, when in trying to protect someone, that might actually do them more harm and deny them liberties that they're due. So let's move into some commonly litigated issues. And I think for our purposes today, I'm gonna narrate. There's obviously some more litigated issues than what we're going to look at today, but it's two of the biggest ones and two of the ones I think that are more likely to affect elderly persons. Are issues over have you met the comprehensive examination criteria? And the second one will be looking at the least restrictive means requirement and standard that the court's supposed to adhere to. And what I'm speaking of here is just to briefly, when you file an incapacity petition, the procedure is as follows, basically for all districts here in Florida today. The court immediately assigns an examining committee of 3 members, one of which must be a doctor. They're charged with performing what is called a comprehensive examination as required by the statute. And based on those examinations, the court will usually use them to a very large degree to determine if the person is in fact incapacitated. If you get 2 out of 3 that says no incapacity, actually the court has to dismiss the petition. If we get a mixed bag or there's unanimous, then there's a hearing, and the reports, if you ever can be admitted to evidence as part of the proof of incapacity, if you get over the evidentiary issues that go with that hearsay and foundation and such. So these reports can be important, but more than that, imagine if you're an elderly person and you're told that there's a court order in place that 3 people are gonna, in the next maybe 24 hours, as little as 24 hours notice, is going to come and they're going to conduct an examination of you, and you must sit for this examination. You have no, very little prior notice. You don't know what they're going to ask you unless you, are lucky enough to know someone who can fill you in on what's most likely going to be asked in any kind of incapacity examination. And you don't, and you're going to be presented with questions, and there's always questions. Sometimes there's a test to draw out a clock and testing memory and things like that. It can be an intimidating process. It would be intimidating for me, and I'm certainly not elderly yet. But I bring that up because I think the process itself, we need to recognize that we're already putting someone through at least what I would call an undignified proceeding, even before we get to the incapacity hearing. And sometimes I think it gets overlooked. What is a comprehensive examination? I see so many examinations come back. Well, I looked at the medical records, and based on the medical records, I'm just going to, they essentially cut and paste what the medical records say. And based on my observations when I met with them and evaluated them, I agree with the medical doctors. I would argue certainly that's what help has that done to the court? What has that added to the court to consider? The court could look at the medical records, and the Cook case actually goes through what needs to be conducted to be a comprehensive exam. They note that there's got to be in person. You've got to see the person. You've got to actually examine the person. There's been this practice of using virtual means for examinations, and certainly they were necessary during the COVID era. But they've kind of, there's been a retaining of those, and many examining committee members will not even see people unless they can see them by virtual examination. I, as a practitioner, would argue against that every day. Unless the ward has some kind of medical condition that keeps them from seeing someone up close, it can present some kind of danger, they're entitled to have a person examine them in person. Virtual, certainly it's not the same. You're trying to determine and make an opinion as to this person's incapacity. There could be issues related to the elderly person not comfortable in front of a camera, nervous about using the equipment, unsure of who they're even speaking to because they're looking at a camera. It really, I think, gives an opportunity for there to be conduct that's misinterpreted as part of incapacity. And it's really just the confusion that's being added by the means you're using. I certainly would argue if I'm not representing a ward, it has to be in person unless there's a compelling reason not otherwise. And and I think that's exactly what the statute says when they say every individual must be examined. So that's an issue that you can always bring up if you think that the exam wasn't comprehensive as the statute requires. They're supposed to conduct this independent exam. It's supposed to have mental and physical and functional assessments. And the court reversed an incapacity finding because these mandatory components were missing or they weren't adequately addressed. The statute protects individuals' due process rights and autonomy, as the court said, emphasizing that shortcuts or omissions in the evaluation process are not permitted. And I think this is now why you have legislature that now mandates training for committee members to ensure compliance with legal standards. That's a relatively new addition to the Guardian statute. Because I know for many years, and to this day, I still see reports come back. Well, did you talk to the family doctor, which is one of the things that's in the statute? No, didn't have time, or or no explanation why it was done virtually. The court's emphasizing here, this is not a procedure to make shortcuts on. We don't make shortcuts on people's due process rights in a criminal proceeding. Why would we do it in an incapacity proceeding? And I think that's something that people need to be aware and not accept, even if it is sort of the status quo for examining committee members to take a lot of shortcuts. I think that it behooves all of us to raise this as an issue and say, no, let's look at what the Cook v. Cook said. Is this really a comprehensive exam, or is this someone that took, just time to review a few records, parrot the records, and didn't really go through any individual independent examination of this person? That's one of the places that I'm starting to emphasize when I'm defending these cases, because I do have concerns about some of these examinations. I want to bring your attention to, now that we have that training requirement for guardianship committee members, that they have to get a 4-hour course and then keep a CLE up every two years for 2 hours. There's there's available resources of what's taught in those courses. And I think if you look at what's taught in the standards they're supposed to adhere to, and then you look at some of the reports, you'll see a big discrepancy. You can get those online. The Florida Guardianship Office, I think, puts forth the 4-hour course, and their materials are some of their materials in reference to the courses online too, if you'd like to see that. I also know the 6th Judicial Circuit has online courses and standards and procedures that would be, I think, interesting for anybody to look at and see what these committee members are being told to do and how it compares to what they actually do, and would give you fodder and grounds for if you're trying to attack one of the exams as not being comprehensive or sufficient for the court's consideration. Now, putting aside the comprehensive exam issue that I think is fraught for litigation, especially when it comes to an elderly person. One more thing I want to know on that before we move to least restrictive means: the language requirement. People overlook that because someone can be in America for many years and speak really good English, but it can still be their second language. And you may presume, well, they've lived here 50 years, they speak English perfectly. When you're dealing with elderly folks, there are many studies about this. As people age, it's natural to start forgetting things, even if incapacity is not an issue. One of the first things you stop or have a hard time recalling is the most recent language you learn. And that's a reason why that's in the statute, that it should be done in their first language, even if they're really proficient in English, because they may be forgetting words just because of the natural process of aging and regressing a little bit in what we recall. And it may have come across as incapacitated because they can't remember what that word means that you're saying, not because they don't understand, but because they're not recalling the second or third language they learned in life as well as they do their first language. emphasize and make sure that when these exams are being made, they're being made with an interpreter or translator that speaks in that person's first language. Otherwise, you may have behavior that manifests that's not really a sign of misunderstanding or confusion, but just a lack of the natural progression of not being able to recall all the words in a language that you learn later in life. And with that, we're going to move to the second, what I think is the second biggest issue in litigation, matters involving guardianship that deal with elderly folks, especially, and is the least restrictive means standard really being considered and met in the courts, and how does it intertwine with all these other procedures we've talked about? And Mr. Eric Boughman, I know you've now become unwillingly very well versed in this area because it's starting to flow over into your practice, and you found out some things that the law has about this, but some gaps that seem to be missing. So I'm going to turn it over to you now to take us into this part of the law.
Yeah, happy to give you my perspective as someone who doesn't practice in this area regularly, but I've done I do mediations regularly in this issue. This is a very common issue that's come up in mediation. I've done a couple recently that have involved, questions over capacity, and often it involves and Teresa, you predicted this several years ago, that this is often what used to take the form of a probate fight, where parents pass away and the kids are jockeying for, or the heirs are jockeying for control of the assets. And now that's happening while the parents are still alive, but then there's this question of capacity. We've also seen it, as you know, recently in the context of divorce, an older, often, older, maybe a second marriage, where one spouse marries a much younger spouse, and then the younger spouse, rather than going through a divorce proceeding, is gaining control of the assets in another way through some declaration of incapacity. It's tragic, really. If you have clients who've dealt with this, I've clients that I've worked with for several years who've gone through this and are going through processes like this. You try to take steps. I'd encourage everyone to you review your own plans, or get with counsel, or get with Teresa, so contact somebody in our office, and make sure you have plans in place to address provide a framework to protect you in the event of a partial or total declaration of incapacity. And what's shocking to me is the apparent quickness with which folks will move towards a petition for incapacity, and where the courts sort of go lockstep. And I imagine a lot of this has to do with the fact that the courts are busy. There's a lot, they have a lot to do. Judges have a lot to do. It's tough to get examining committee members, who are going to provide time to really provide an in-depth analysis. And then we've got this test, as you've talked about before, Teresa, and you mentioned this earlier, the test for appointing a guardian that has, as I review it, and I look at the statute as again someone who doesn't practice in this area regularly but is quite familiar with it. There's two independent prerequisites to appointment of a guardian. You have a finding of incapacity, and then if there is a finding, if there is incapacity, there also has to be a determination that there's no less restrictive means to adequately protect the person who's declared partially or totally incapacitated. Well, it seems to me that the courts are taking an approach, and attorneys are taking an approach that's a 1-2 step. One, let's declare incapacity or find incapacity, or do a test for that in a hearing, and then let's take the second step. But I'd like to point out, I have a couple quotes from cases that I think are very that really kind of highlight this. This is what what courts have said about the guardianship process, not out of my words or yours. And one is out of another court from a different state, a Supreme Court of Iowa, in an older case, from the 90s, where the court said that guardianship reduces the disabled person to the status of a child. It results in substantial and often unnecessary forfeiture of rights. The stigma of incompetence implies that one is mentally defective, untrustworthy, and irresponsible. And Florida courts have had similar findings in a 2015 case. This is one that we cited in some papers that we filed recently. In our present-day paternalistic society, we must take care that in our zeal for protecting those who cannot protect themselves, we do not unnecessarily deprive them of some rather precious individual rights. And there's other quotes. There's a 2024 case, Silva v. Silva, where the court recognized that guardianship proceedings are, by their very nature, intrusive and, as in this case, often sometimes initiated against the wishes of the ward. And I've heard attorneys and folks involved in this refer to the process where somebody who's being assessed for capacity has less rights than a criminal on trial. Essentially, as you mentioned earlier, Teresa, they may not have the right to determine who they visit with and see, and just basic freedoms that we take for granted. And when you consider these quotes and this recognition by courts, the Department of Justice has an elder justice, an entire website set up, the Federal Department of Justice, looking at some of these issues. There's been academic papers that have been written on it. It brings me back to this test, this two-part test of a finding of incapacity and a determination of a less restrictive means to protect the person. Why are we looking at it through that prism? Why aren't we looking at it through a different prism? And this is the question I have for anyone in this area. If we can show that a person has done pre-planning and has trustees in place and appointments and power of attorney appointments, designated healthcare surrogates, trustees, folks to take care of specific needs that might be removed from them, then why do we need to go down the path of making a finding or putting somebody through the process of examination, professional examinations, and doing the reports and potentially going to a hearing to determine whether, as the Iowa Supreme Court said, their status as a disabled person is reduced to the status of a child or less? It just, to me, seems like a backward process. And so I would encourage folks to, really look at this second element, which really isn't the second part of two elements. It's just one of two alternatives. You have to find both. As I understand, for the guardianship, you have to find an incapacity and you have to find no less restrictive means. Well, if you know that the pieces are in place so that there are less restrictive means, such as trustees and agents, to care for the person and take care of specific needs, then why do we even have to waste the court's time and medical professionals and others and put the individual through a potentially demeaning process of determining whether or not they have capacity, if at the end of the day that decision isn't going to matter? So I've thrown a lot out there, but that's really, to me, the overarching issue I have with the entire guardianship process, both as an attorney and as an individual who has interest with friends, and as a third-party mediator looking at these issues and wondering, why are we going through this process if there's another way to address the potential issues without putting the individual, the innocent individual, through this really terrible process.
Yeah, thank you, Eric. And I absolutely agree with you. I also, like you, I advocate now for pre-planning for individuals, with living longer. Thank goodness with our new medical, marvels that we have these days, people will live longer, but that doesn't mean that the toll of age won't take out its ability to take care of your affairs at some point. And just like we do estate planning, guardianship planning, in my mind, is just as equally or maybe more important, since it's going to affect you while you're still alive. And I know you've been an advocate for this too, but we're often sometimes frustrated because sometimes people listen to us, they get this good planning in place. But if they do have someone, that files an incapacity proceeding, usually going to be someone that doesn't maybe have their best interest, or they've recognized already that they have things in place, they're subjected to go into those committee, or appearing before the committee members and being examined and being asked in questions. And what we'd all say is a pretty undignified process. Nobody wants to be, told, can you remember the president from this year and things like that, and be put on the spot like that, even if they have this planning, at least as it relates to the procedures that I know of throughout Florida. And I think what we're both saying is, well, let's look at the law. Why does that have to be? Why can't the judge first look at this least restrictive means as sort of a threshold issue? So, and so that's what I kind of put here on our screen here. What does Chapter 744 get right? What does it get wrong? I think it does a great job of emphasizing that we're not going to put guardianship and impose that on people if they've already got, sufficient procedures in place and alternatives in place. But it kind of forgets to let the courts know, hey, maybe this should just be a preliminary issue, in fact, because, we may not even need to go down the road of incapacity if they have in fact done good planning or have those abilities and resources available to them that will protect them without the need for a guardian.
And the
And
irony is, we're often talking about folks who are struggling. Maybe there's early onset of some form of dementia. As we get older, we forget things. And I've been involved in observing some of these examinations. I'm not sure I could get all the questions right. Because sometimes we forget things. But then the process itself is widely recognized from what I could see by professionals. I'm not a professional healthcare person in this area, but it seems to be widely recognized that the process itself is very stressful and can in fact exacerbate a mild condition in somebody who's going through the process. So, if we're going to at the end of the day make a determination that we don't need to appoint a guardian because we haven't reached either the clear and convincing standard, but putting that aside, if we have the least restrictive means that are there for protection, it just baffles me that we would continue to put folks through that process without taking a look at that second element and really not wasting the court's time and wasting, examiners' time if they're going to make a report that's not going to be used to do anything with it because people have less restrictive protections already in place.
yeah, and think about what a waste of resources. You have three individuals that are paid what the courts have decided is a reasonable wage, probably what they don't consider, their fees. They're paid a, let's just say a minimal fee. Professionals to go out and conduct these things. Attorneys sometimes have to be present, arrangements have to be made, caregivers, have to be notified. A lot of things go into getting these exams done, especially in quick order. Sometimes there's not money to pay the examiners because the court only has authority to order payment from the ward's asset if they're declared incapacitated. So then you have examining committee members sometimes not getting paid unless there's state funds available to pay them. And then of course the court work that goes into entering the orders for an examining committee and all those things. All that gets done is a huge use of resources, and it may all be moot if they already have these other less restrictive means in place. And so with all that, and as you described, such a hard process to put someone through, I think we're both kind of concluding it'd be nice if the Florida procedures, I guess, caught up with the law and had a specific procedural rule that said, as a preliminary matter, the court should consider if there's an assertion made that there's less restrictive means, make a preliminary finding. If there is going to be less restrictive means that we're not going to go down the road of incapacity because it will be moot to the question of whether a guardian will be put in place.
And for professional advisors, most of the participants in this, are folks viewing this webinar will be in some professional capacity. If you have clients who are potentially in this boat who are vulnerable to this in the near future, you should be advising. In my view, pre-need designation of guardian it can be very powerful. Have power of attorney appointments, a full estate plan that accounts for the fact that somebody might lose capacity. If nothing else, it can disincentivize people with bad motives to try and get control of an individual and specifically their assets through a guardianship proceeding. Because that's been what I have seen is most of the time, and whether it's in with clients or in mediations when I've observed, people talk about wanting to protect mom and dad or Aunt Sally or whatever the circumstances are, but it comes down to often, almost all the time, control of assets, control of money. And we see that with the professional guardians too. That, if you control the assets, you control the money, there's motivation there to act. And when you take that motivation away, or you make it obvious it's going to be very difficult to reach, you can do this through trusts, and especially trusts where you move the what we've advocated for clients in certain situations is create asset protection trusts that move the control of the assets outside the control of the individual, if it's you or your client, put them in the hands of a third-party trustee, preferably outside the jurisdiction. We all use Nevada that has a good self-settled trust statute, and put those assets and the control of the assets somewhere else. Even if the court wanted to, if you had a court that was going off the rails and decided to appoint a professional guardian or a child or somebody else, a younger spouse with bad motives, and give that person control of the assets. They won't have control if the court can't wrestle the control away from the trustee. And if the trustee is not in a jurisdiction, we've had this challenge before. You try to sue a trustee from Nevada who doesn't have any presence in Florida, who is a trustee over a Nevada trust, and the assets are in Nevada if it's cash or other types of assets. And even if they're here, it's better than nothing. You try to sue that trustee in Florida, chances are the trustee is going to file a motion to dismiss for lack of jurisdiction. And then now you're going to have to go to another state and fight. And that's probably going to put an end to that battle for most people who are trying to get control of the assets. It's like when we've seen partnerships disputes, shareholder disputes, divorces, the assets, whoever controls the assets usually has the upper hand.
Yeah, all good points. And I've skipped ahead a little bit on our slides here if you're following along, because that was a good leeway into this weaponization of guardianship. When I think we've already gone through cases where people have good intentions, and it can be in guardianship, the whole procedure can be very uncomfortable. But when you have maybe an unscrupulous individual who wants to gain some kind of leverage over the alleged incapacitated person, essentially wants to make them, put them in an uncomfortable position, so maybe they'll get what they want, some kind of control over their assets. The guardianship procedure and the incapacity procedure really sets them up to abuse that if they're so willing to do. And what you've described is, essentially doing planning that will hopefully disincentivize people from doing that, because even if they are, even if they have you declared incapacitated, they're not going to have the people that control your assets are outside the jurisdiction of the court, and well outside what they can get their hands on, even if that happens. And that's as odd, as almost counterintuitive as that seems, to have to go through such lengths to keep people from being with bad motivations to make your life miserable in your later years. I do highly recommend it, because I think that the incidents of seeing this kind of behavior are certainly up. This was such a rarity 20 years ago when I was practicing 22 years ago. And now I'm almost astounded at how common it is to see this scenario. And as we've seen from those statistics that we looked at earlier, it's only going to become more and more prevalent. And so some of those ideas you had, I would say those are all good things. Especially, we all do estate planning, do guardianship planning. And I get asked sometimes, well, I have good family members, or I have a good spouse. Why would I do that? And I say, you don't know what what life will be in 5 years or 10 years. Maybe your spouse is gone. Maybe the family members you trust are gone, or they're, for whatever reason, they're dealing with their own issues. And so, and essentially they're not around you to protect you anymore. And maybe someone else has come to the forefront. Sometimes people get in financial difficulties, and it makes them do things that you never thought they would do. There's all kind of reasons that it happens. I mean, it does happen. That's just the reality of it. So, look at it, it's just better to be safe and sorry, and have some planning put in place. So if anybody ever did get this idea, it won't work out the way that they thought it was going to work out. Hopefully with all those bars put in place and those obstacles put in place for them to get control of your financial assets, which is usually what the motivation is. And we're in the age of the celebrity guardianship and conservatorships. The news is full of everybody. The Free Britney movement a few years ago, it was kind of a light moment. You're laughing, but when I looked at what was going on, it was kind of scary that in the public eye you could see someone have a lot of rights taken away from them, who clearly had some capacity, but all of a sudden had no control over anything as far as their body and their finances, and relatively young, all those things. We all kind of saw that drama play out. We've got a recent one with Wendy Williams, and she's a talk show host, and I'm interested in this topic, so I looked a little farther into her case. Right now, as I understand it, and for a few years now, she's been under a complete plenary guardianship in New York, and having a hard time, as she claims, of contacting or talking to anyone. That the people that are in charge of her, her guardians, they make it so it's hard for her to talk or visit with anyone. And apparently she's got away and got a phone and called news organizations to get help. And again, she had a diagnosis of some brain damage and some aphasia, which, if anyone's familiar, aphasia is, it's not an inability to think or things like that or comprehend. It's just an ability for your essentially the words to get to your mouth. So you can absolutely know what the answer to a question is, but if you have aphasia, you just can't say it. So sometimes it can be misinterpreted as, oh, this is an incapacitated person. They don't understand my question, when really they just can't say the word. They know exactly what they want to say in response to your question. So it sounds like she's got some issues going on, but maybe some that aren't, that it's rare for an completely incapacitated person to be able to have the wherewithal to somehow find a phone and call out and ask for help like that. And everybody's watching it with fascination now, because you're seeing one of these, nightmare scenarios that we think, one in a million, and we're seeing it play out. And so, I'm anxious to follow that and see now with the public scrutiny, how the courts maybe readdress that guardianship. And from what I understand, of course, this is just reading news articles and interviews with people. This was initiated by her bank and her financial, the financial folks. Um, and she didn't have any close relatives or people around her that was willing to take the helm at the time, and she is where she is now. And so we're going to see some of these things play out in public. So let's talk. And people out there may have examples of when guardianship can go wrong for the average elderly Florida resident. And I think Eric, in his explanations, he's seeing those in real time too. You have the spouse that maybe is not on equal par with the younger spouse as far as mental acuity. And if someone wants to get a divorce, they figure out, what, I can get control of everything if they're incapacitated, as opposed to taking my chances, in the divorce court with equitable distribution. Probate, you have the child that, maybe a ne'er-do-well, he's not done well financially. I don't want to wait till my parents are going to be alive for a while. Right now they're splitting up the money equally with my siblings. I don't want that. But if I declare them incapacitated, or try to have them declared incapacitated, and I take control, I can make sure that my share comes to me, a little quicker. And and I don't know if any of you out there have any examples you want to share, or if you have any more, Eric, that you can think of offhand. But it's a little unbelievable how real life scenarios are playing out around us every day in Florida.
Yeah, I think you hit on them pretty well. I'd be interested if anybody has questions or input from your viewers today. But this seems to be something that's growing. Here's another interesting point. Um, there was a show on Netflix. What was it called?
I care a lot.
There was that one, and then it was Greed, right? There wasn't
Oh,
a
great. Yes.
Greed that had an episode about guardianship, specifically focused on Florida guardianship. And that episode's no longer available. So I wonder what happened there. I mean, it's
I
almost
heard someone got sued and they took it
that's
off.
usually what happens, right? There's a
Mhm.
lawsuit, like somebody posts something, they did an entire episode on Netflix. And then all of a sudden that episode, you can't find it anywhere. And it makes me wonder if somebody got sued. So, talk about using the courts to silence individuals from speaking out about this. That sounds like what was going on there. But the show that you referenced, Teresa, I Care a Lot. You and I have seen circumstances with clients where it's very, very, I mean, you had one case that was eerily similar with your client who ran off to Europe, that was able to escape and actually get out of the country. And I know that because we sat in, you asked me to sit in on a hearing uh, the judge who was just, who was ordering that the person come back and attend for this hearing. And your client that's now over in Europe said, I'm not coming back to the US so that somebody can deprive me of all my rights and her family. Now she just wanted to get her property back. And the professional guardian and the attorney for the guardian are selling off assets, and just a sad, tragic situation. It's almost it would be, it's almost like comedy because you see it in the movie, you're like, oh my gosh, that would never happen. And as it turns out, that happens. And it becomes very close. And this is something that people need to pay attention to. It's
Yeah.
really a problem.
And you bringing up those examples, those dealt with professional guardians, which we haven't talked about a lot today, but I've done other webinars on that. The potential abuses of professional guardians, those shows emphasized, and I think that I was sounding the horn many years ago that I'm seeing it. There's good professional guardians. Don't get me wrong. They're really good, competent ones, and then that industry has exploded with people becoming professional guardians for people who want to take advantage. It's a little fraught for that, and there unfortunately are some. They're
Well, I
being.
wonder why. When you look at the fact that Guardian sells off the ward's assets and gets a commission for selling the assets,
Yeah, there's some things that
there's
certainly can be
motivation to
fixed.
protect, there's not really much of a motivation there to protect the, unless you just have somebody that has
Mhm.
good solid integrity and core. There's a lot of motivation there to sell off assets that don't need to be sold off to simply generate commissions that pay the guardian.
Yeah, that's one of my pet peeves too about the current professional guardianship statute and procedures that allow things like that. And that kind of is a good leeway. We skipped section 3, which is what's on the horizon and law changes. I wish I could report to you there were changes that were coming up that we're going to do, as Eric and I suggested. Let's have a specific procedure that gives the court the authority to bypass the incapacity until they look at this least restrictive means. We don't have that yet. I'm going to keep advocating for it with anyone who wants to listen. But there are some changes, at least some bills that have been proposed that as it's getting closer to July 1st. I'm less optimistic they'll be adopted this time around, but maybe next year. Sometimes these float around for a while and then they get changed. But these changes are actually, I think, are in response to what we've been saying. At least I've been saying on these webinars, and I know you've shared some of my opinions on professional guardians. They really need to start being reined in. They're creating little sub businesses here, and with lots of opportunities for really spending people's money, the money that doesn't belong to them. And so we have Florida Senate Bill 2025-1806, and it has a companion House bill I noted there. It was introduced last February, and I thought it was going to be passed because it seemed to be moving pretty quickly. But at last I checked, as of yesterday, it was still just pending, and so it might not get adopted this legislative round. But I think you'll see it come back up. But these are some of the changes they're proposing. I don't think it's enough, but it certainly is moving in the right direction. And you probably just wondering why it isn't already like that. At counties, when you have a professional guardian, the only person really that is there to keep an eye on them is the judge, which is obviously a good gatekeeper. But they're being given information in accountings, which they're going to take it with as presumed to be accurate. And for a long time, guardians wouldn't even share accountings with family members or other third parties. And certainly the ward, if they're incapacitated, can't review them with any meaningful scrutiny. So they've started fixing that. And now not only is it not going to just be annual, but you're going to have quarterly accountings. But then, as you can see in the next one, then the next of kin has to be notified so that they can, because they actually would have an incentive and ability to look at these and say, wait, this just doesn't look right. I know my mom, she didn't, need all this. Why all of a sudden, is this needed? Or really ask the question, why are you selling off these assets? What's the long-term plan here? So I think that's a wonderful thing for the next of kin to be notified. It doesn't help the ward if the next of kin's not engaged and in the process, but at least one other person other than the judge and the professional guardian is seeing what's going on financially, and maybe will speak up if something looks untoward. Then they have, and then the court's given some authority if they want to change that schedule, make it even more often or even or less often, depending on the circumstances. Appraiser appointments. The bill mandates that the court appoint an appraiser to assess the ward's property. People, Eric had the question, well, what does that do? I know there's a lot of abuse for appraisers. I've seen some situations where professional guardians have a whole list of, appraisers they like, and, and they have an estate with a lot of resources. So the first thing they do is they come in, they appraise everything, the silverware, the cars, and with what to what purpose? Right, I mean, are you gonna? Why do you need to sell the cars and the silverware? Why do you need to sell the house? I have a real problem with people selling person's homestead when it doesn't really need to be done, other than to pay guardianship fees. So I think what they're trying to do here is they're trying to get that issue back in front of the courts, and so when you come to get an appointment for an appraiser, the court can look at it and see, well, what do we really need? And have an eye on that issue from the beginning is what I think they're trying to do here. And then obviously make sure it's an independent appraiser who's going to give you fair assessment.
I would say that it still shocks me that the folks involved in uh, initializing or initiating a sale of the ward's assets have a financial um, incentive and a financial reward in the outcome.
Yeah.
It seems like there should be another party in place to oversee this that's maybe just paid on a flat fee or something else to make an assessment evaluation. We say, okay, you have to go through the courts, but as you know, Teresa, the courts, the judges are just overwhelmed with cases, and it's very hard for them to make a detailed analysis. One judge who I have a lot of respect for, he's several I respect and I know pretty well. One has made an analogy of their job being to that equivalent to an emergency room physician. They're like, look, people come into the court, they're looking for a quick answer. If I try and do what I can, try and get people an answer, get them their day in court, swiftly. And if I do something wrong, I've got backup because people can always go to the appellate court. So I know that I've got a backstop there. It's an interesting way to look at your job as a judge, and I won't criticize that because I think there's a lot of merit in that statement that people want their day in court, but it doesn't give the judges a lot of time for analysis to really do um, an in-depth analysis on whether or not a sale is proper. I don't think the judges are engaging in that analysis. They're trusting the guardians and whoever's filing. There should just be, in my view, somebody else involved in that who's testing whether or not some of these things are proper, or maybe just more of a notice period, a notice to other interested parties. Something else.
Yeah, and I agree with you. And of course, it's helpful when the board has interested parties, when they have family or friends that are actually willing to help them. But a lot of times you have a ward, the whole reason they have a professional guardian is they don't really have anybody, and it's almost an unfair burden to put on the courts to scrutinize everything that a professional guardian gives you. They have to give it some, deference. And I think that's the onus is on our legislature to figure out what they can do to things like this to try to dissuade professional guardians from taking advantage or bringing their misdeeds to light. And the final thing they did was, and I didn't know that the court needed this, but apparently they can refer the case to the Department of Law Enforcement for a criminal investigation if they see the misuse of guardian misusing ward's assets or funds. I presume the judge could already do that, but I think that the reason for wanting to put it into law is to emphasize to the judge that the best way to dissuade, obviously professional guardians from taking advantage is stiff penalties if they're caught. And I think that would be the only reason they put this in here, because certainly the judge could have already had the power to refer cases to the Department of Law Enforcement if they see a criminal activity. The bill, if it gets passed, obviously it's going in the right direction. At least we now have the legislature acknowledging, yeah, we need to rein in professional guardians a little bit. It could certainly go further, and I agree, as long as you incentivize people monetarily to sell assets, you really are setting up a conflict of interest there. And a lot of we've gone through all our sections now, even though we did them a little bit out of order. Eric, again, thank you for joining us, and given your perspective, I think as we said, your perspective, and if you're a practitioner who says, "Oh, I don't need to know about guardianship," you sooner or later it's probably going to touch on your area, and it's just natural um, consequence of having elderly people there. And I really appreciate you coming today and sharing your perspective from it, your ideas. And I think conversations like this, making the public and other professionals aware of some of these issues, that's how we get changes. And I'm still hopeful that we'll one day see that procedural change that you and I want so much, that least restrictive means is a threshold issue.
Yeah, folks really need, the takeaway here is to really make sure you're watching out for folks that you're advising, and take some of this very, very seriously.
Now, as always, we welcome questions. We welcome you sharing your stories, even if it's not today during this webinar, which is we're about to come to our end here in a few minutes. Please feel free to email myself or Eric. Our information's up here, including our emails, our phone numbers. We love to hear from people. We like to share our experiences. It's how we all become better practitioners, how we can help people better. And please don't be shy about contacting us. We actually get thrilled when we get one of those emails.